how a lot is happening in the society today. The quick notice thing, the relationship that exists, who is supposed to do this, who is supposed to do that. A lot of fights, a lot of quarrel, more so that we have so many people migrating to the urban centers. You know, and for the fact that there is some housing deficit in Nigeria, not just in FCT alone. And I have a legal practitioner, a human rights activist, and a notary public right here with me today in the person of Barrister Alex Ogbo, Esquire. It's good to have you join us this morning.
It's a pleasure to be here to look into this very sensitive topic. Thank you so much.
All right, let's look at it. You know, many times, all right, the relationship between the landlord and the tenant have a lot of issues. You hear, all right, I don't want you to stay in my house again. Pack your things and go. What is the place of the law as it has to do with tenant? Let's just look at tenancy agreements. Well, what's the place of the law? How is this supposed to be? What are the rights of a tenant in the house of the landlord? We also look at the rights of the landlord too.
Yes. Really, the issue of landlord-tenant relationship is well defined in our laws. Like in a city, just as is applicable to most states of the Federation. If a tenant is paying annually, tenancy for a year. First of all, once the tenant complies and pays, the tenant is supposed by law to be granted unrestricted freedom, to enjoy possession of the premises. All right? And the landlord is not expected, or the landlady, to go and disturb the tenant. If there's need for the landlord or the landlady to go and do inspection, you first of all give prior notice to the tenant that you want to come and inspect the premises for whatever reason. It has to be a prior information to that effect. Outside that, the landlord or tenant or his or her agents is not allowed by law to go and interfere with a tenant who is in occupation of a premises. Then, being someone that pays yearly, if the landlord or landlady wants to give any notice, maybe quick notice on the expiration of the tenancy, the law states that such a notice should be given 6 months before the expiration. If someone's tenancy is to expire by December, maybe let's say 31st December 2025, the law provides that the tenant should be served quick notice from the 1st of July 2025, so that by the end of the year, it should have been 6 months. So that's the provision if it's a yearly tenant. If it's a half-yearly tenant, the person is entitled to 3 months notice. If it's a monthly tenant, a month notice. If it's weekly, 1 week notice. It depends. But here, we don't operate weekly as you see in other countries. So there's always this provision for the time within which a tenant should be given a quick notice. And if such quick notice is given and it expires on the 6th month, then the legal provision is that the landlord or landlady should now serve 7 days owner's intention to recover possession to the tenant. All right? If the tenant has not moved at the end of 6 months. And after the 7 days of owner's intention to recover possession, if the tenant still doesn't move, then you go to court, file the processes, serve the tenant to come to court and be able to explain what actually is going on. So the legal process starts in the court. Now, also, a tenant is expected to take care of issues like, power supply, issues, light bills, the use of, there are certain outgoings like the use of, effluents, issues that come from the toilet and all that. When such, like we call it the soakaway, gets filled up, is the tenant that is using that. So the tenant should be able to take care of the evacuation. But if something like the Sogeway bursts, it has come to the project itself, the building, the landlord is expected to come and repair. The same thing happens to the building. If there's any structural defect or error or crack and so on and so forth, or leakage, the tenant should allow the landlord to come and effect repair of such things. But the tenant is expected to keep that property in what the law calls tenantable condition. When you come into the property, okay, the doors are okay, the windows are okay, the roof, the ceiling and all. You keep the house neat and tidy. There are some tenants that when they get into somebody's property, the way they use it, by the time you set your eye on the property, you become so discouraged. Some people are willingly and carefully, determined to be lousy and dirty. It's not expected of a tenant. If a tenant misuses a property, it's one of the conditions that can warrant a landlord to issue a quick notice, because the property has been kept in a state of untenantable condition. And when a tenant is to quit, it's also supposed to put that property together the way it was when the tenant comes. But in this country, we know that most tenants do not do that. Abroad, you cannot leave a property, in bad state when you are living. You have to put it together, or you pay the financial equivalent. If they want to go to court and it's established that someone has abused the property, the law will award to the landlady or landlord the money with which the repairs should be effected. Okay? And the tenant is not allowed by law to owe and go with it. Any single hour you owe or day, the tenant is expected to pay. Now, for the landlord, these are the things that are beneficial to the landlord, keeping it in good condition. The tenant is given a lot of rights, undisturbed possession. As you live there, nobody is supposed to interrupt or disturb you. Even if the landlord is to send agents, like I said, there had to be notice prior to such a visit, But one of the things that is causing big problem in this country now, once the fresh subsidy was removed and the federal government embarked on increment on everything, water rates, power supply bills, in terms of just everything is increased in this country. Because of that, all the landed properties, all the buildings have their rentages increased astronomically, and it's unbearable. But because of the state of the economy, so tenants are finding it very difficult to get properties to rent, and because of that, you see, there are this challenge of quick notices left, right, and center. But the state of the economy is what is causing the problem, because landlords or landladies do not operate in isolation.
But does the court recognize economic situations affecting? Because as it is, if there is an increment and the tenant can't pay, all right, and it resulted to owing so much, if the case gets to court, does the court recognize the place of hardship in the law?
No, you see, what the court does is to interpret what the agreement between the landlord or landlady and tenant is. What did they agree at the point of the contract, tenancy contract or agreement? Because in that agreement, the rate or the amount to be paid is usually stated. All right? And that is the agreement which the tenant has subscribed to before moving in. And when you move in, the law expects you that you should abide by that agreement that people made. So the law will not come to alter the price for the tenant or the landlord. They agreed about it, and the tenant accepted and moved in. What the law is trying to do is that let there be compliance, and two, let the landlord give unfettered access to the tenant who has paid and moved in. But if a tenant is owing, the law is out to assist the landlord or landlady to recover what is being owed. if a matter goes to court, at times tenancy issues or cases can linger in the court for 2 years, 3 years, at times 4 years. Within those periods, whatever the tenant is owing, the law will mandate the tenant to pay. You know, so that is what is there. And you know, there this general notion.
So let me just come in, because that is very sensitive. That period of 2 years that the case is in court, would the tenant still be in the house of the landlord paying, or you will just be there to clear the backlog? What about the ones you're staying when the case is in court? Will there still be payment for that period?
Yeah, it's good to ask that question. Once a landlord serves a tenant quit notice, all right, the law assumes that the tenancy terminates at that point. But every other hour or day the tenant stays, that's what is called the mean profit. All right. For instance, if a tenant pays, just for illustration, 12,000 naira per year, it means that a month such a tenant pays 1,000. One tenancy, quit notice is served, then the tenant is expected to be paying monthly what is supposed to be when you spread it out for a year. So it's counting from the time that notice is served. Anything the tenant have owing before the notice is served is still a debt. Then every other day the tenant stays. Per month, the tenant must pay to the landlord and landlady everything that is supposed to be paid monthly. So as at the time the case is decided in the court, all the period the tenant stays will be calculated together with whatever the tenant was owing before the notice was served, all had to be paid to the landlord. So he can't stay free. And let me quickly chip in this. Most tenants, I don't know where they get the idea, believe that if a landlord or landlady serves a notice, that you should give them 3 months until you give them 6 months to go and look for alternative, free, without paying. There's nothing like that. Any single day you overstay, even an hour, you overstay in somebody's property, you're owing, and you have to pay for it. If at the end of the court process you didn't pay, the landlord or landlady will still go to the court for enforcement of whatever judgment the court has given. There's an enforcement unit in the court. By the time the process is started, the enforcement unit will come with security officers and take every property that belongs to the tenant to the court, which the tenant is expected to come and repossess after paying. Or in the event of not paying, it will be laid to auction. It will be put up for auction. After that auction, the payment, the debt be owed by the tenant is defrayed to the landlord, paid back to the landlord. Whatever balance remains can go back to the tenant.
All right, let's look at the issue of some landlords giving the tenant the instruction of how many people the tenant can bring to the house. Is that constitutional? Because you talked about the fact that if you have paid, all right, if you have paid for the facility, you have the ownership, and you possess the ownership, of the premises.
Yes.
But some persons will tell you, this is my house, I don't want more than 2 persons. I don't want more than 3. I don't want more than 4. Some will tell you, I don't even want 2 female or 2 male. It should be a male and female, or it should be just female. Such a prescription and directive, is it constitutional?
That aspect is not even very pronounced in our country now. Abroad, you see it being highly operational. That a particular space, 2-bedroom flat, 3-bedroom flat, should be occupied by so and so number of persons. Tenancy laws provide for that. Here, our people are not yet strict, though some may be implementing that. There used to be legal provision for the number of people that a building capacity can take in order not to overstretch the facilities provided in the building. All right. So there used to be a legal provision for that, but implementation is not strict here yet. Abroad, people will let you know that it's very strict. In fact, when we were at the university, one of our lecturers gave us an illustration. He went to UK for a study and paid for a 3-bedroom flat. By the time he concluded his travel documents and facilitated his movement and visa and all the rest, that he moved with the wife, either was it 2 children or so, and his mother. By the time they got to the place, it's a landlady that owns the property. Once the lady saw them, she said no. He instantly refunded their money at the entrance to the house. That this number cannot enter this house. 3-bedroom flat. The man was shocked. If it is here, more people should have joined. Refunded the money for him to go and look for a bigger facility that will accommodate them, that they will overstretch the property. So the law used to make some provisions. The implementation is not strict here yet, though some may be invoking that. And that will also make people to really appreciate the challenges of rentage. And 2, it will also make some tenants to, there are some tenants that abuse the provisions. You get into someone's property, you're supposed to handle it as if it's your own. But some will mess up the place, dirty it, allow the structures to get dilapidated, to be destroyed. There was a particular experience I had. I was to enforce this issue of a notice on a particular property, and by the time I got there with the landlord, I don't know how the man did it. If you get into the kitchen, you vomit. From the floor up to the ceiling, everywhere was filled with soot, dark soot, all over, all the 4 walls. The windows were broken, the doors were destroyed.
And he was living there.
He was living there with the family. He was still there. So one wonders, how do one do it? That smoke will stain the whole walls, windows, everything, and you feel comfortable. You cook there and you eat. You yourself, your wife, your children. So some people are reckless. There are tenants that when you have them, you enjoy their being in your property. Because people don't just issue notices anyhow. There are some tenants that are troublesome. There are also some landlords and landladies that are troublesome, vice versa. So if you meet a troublesome tenant, such a tenant will always have issues with landlords. But when you get a good-natured tenant, you see that a landlord or landlady will not really want the person to go. So it's important to treat one's property as if it is your own and have a good relationship. In the sense that there are people, the way they lack manners, the way they talk and all that, the way they react is all about abuse and insult. These are the things that provoke this issue of notices. And you see, this we call them statutory notices. Notices that have to serve to a tenant based on the length of time, whether it's a year, the person is staying, or half a year, or 3 months and all. The law also made provision that if a landlord or landlady wants to make use of a property occupied by a tenant, it could be that a member or members of the family of the landlord or landlady are coming in. Then the law provides that the notice that should be served could be abridged, will not be up to the length the law expects. Notice must be given, but it could be shorter than what is expected. Like instead of 6 months, it could be a shorter period, for the reason that the landlord or landlady want to make use of the property, either a family member or that, is to come in. All right. So, but where also a landlord embarks on inspection and discover that the property has been so badly misused by the tenant, is a breach of the tenancy agreement. Because in the agreement it stated that this property should be used in such and such a manner. It sees some provision that there will be no storage of explosives in property, all right, and so on and so forth. If you declare that a tenant is bringing in such things that could make the security agencies to put the landlord or landlady in a bad state, that is a breach of tenancy agreement, and that could lead to notice being served that will be shorter than what is provided by law. So interrelationship really matters.
Barrister, there are some houses or some agents in Abuja. Okay, landlords. Let me just begin from the issue of tenancy agreement. Some places you just see an agent just get a house for you and all of that, and the only thing you get is a receipt, just the payment receipt. Most of the houses, not just in FCT, in some parts of Nigeria, does not have tenancy agreement. You just get into the house and all of that. So how can you enforce or maybe implement all these laws if there is no tenancy agreement, if there is no agreement?
Actually, you see, when an agent or a landlord or landlady lets in a tenant, and there is no tenancy agreement, is a dangerous trend. Yeah, the receipt is very crucial because it's evidence of payment. What the law says, if there's no tenancy agreement that specifies the relationship between a landlord and tenant, but there's that evidence of payment, what the law does, when it comes to issue of notices to be served, the law now looks at the mode of payment. If this payment is yearly, the statutory arrangement is brought in by the law to define how the notice should be served. It should be 6 months. If it's half yearly, it should be 3 months, and so on and so forth. But where there is no agreement between landlord and tenant, it's not a healthy condition. So any agent or any landlord or landlady that lets in a tenant without tenancy agreement is not doing himself a favor, because tenancy agreement specifies in clear terms what relationship should be. Where there's no tenancy agreement, most of those opportunities you have to talk of what the relationship should be, you don't have it properly. It will only take maybe legal intervention in the court to start defining, because there's nothing stated. Okay, though it doesn't give the tenant a leeway to also behave anyhow, but tenancy agreement is very important. In fact, the law says that where there's tenancy agreement, and in that agreement a landlord and tenant has agreed that the mode of notice that should be served should be shorter than what the law statutory provides, that agreement entered into by the two will eventually supersede. There are cases where a tenancy agreement states for a yearly tenant that a notice should be 3 months. If a tenant accepts that, the law allows it to go through. You know, so these are the things. Tenancy agreement helps so much both landlord and tenant to define conditions. For instance, the illustration you gave, where a landlord is saying that so and so number of persons should not be allowed. It is tenancy agreement that needs to specify that. If you specify the tenancy agreement and the tenant is comfortable with that, then you're expected to abide by it because you saw it and you signed. If there's no agreement, you can't enforce that. A landlord cannot come later and tell a tenant that no, I can't allow 6 people into this place. You don't have such a right because there's nothing specifying that before the person entered. So that's the benefit of an agreement.
All right. Let's look at the activity of this. Is the estate agents, they call them, or house agents? These people who parade themselves. Estate agents. You know, you pay them to help you look for the house. Then there is a percentage they get afterwards. These people, according to some Nigerians, said they are the ones that even dictate to the landlord to increase prices. Like you were talking about how prices of houses skyrocketed after the removal of subsidy, not minding whether the economy is stable or not. And these people are after their percentage, because the higher the rent, the higher their percentage and their commissions. Is their operation legal, and do they have the legal right to increase this money? the rent.
When it comes to the function of the estate agents, they are middlemen. They are very important in the society in the sense that when a tenant is looking for a space to rent, you may not know where to get it. Even a landlord that has a property, you may not also know where to get tenants to come in. It is these middlemen that help to scout and get tenants to come in and get landlords that have a place to rent. So they are middlemen bridging the gap. The law recognizes them. And it is these middlemen also that are very conversant with the current rate of properties in whatever location. Because they operate on daily basis, they know what the worth or the value of a property is at each point in time. If a landlord wants to overrate a property, these agents will let you know that this place you are is not up to this, because this is what prevalent is prevalent in the place. So they are current with information. If what the landlord has in mind or landlady is also lower, they will let you know that this place has appreciated because of the current affairs they have. So they are very crucial to the society, really. Their rate also, they are even very strict when it comes to their rates. Most of the time it's 10%. They were in some areas, you see some of them talking of 15%, 20%. So the law recognizes the activities of the estate agents. In fact, to the extent that the law is even prohibiting lawyers from acting as agents. You are entitled to your legal services. Prepare documents, you charge for that, and get paid for that. But the law is even fighting lawyers from being estate agents.
But some lawyers are doing it.
It's
illegal?
Some are doing that, but the place of estate agents is strictly recognized by the law. That these estate, because like I said, they are middlemen, and they have a great role to play in the society. So the law recognizes them. Okay? You can't do without them, really. If you are looking for a property, you don't even know where to get. It's these people. Just by a snap of a finger, they give you details.
And they have a lot of connects.
Their
network is something else.
And why you see that they even charge that 10% is when that payment is made, it's not that person you are seeing that takes the whole money. They share it according to the information.
Yes.
Because if we link up with some others who will let you know the one that is available, at the end of the day, they share this among themselves. So they are recognized by the law.
All right. Thank you very much. I would have wanted us to talk about the rights of the landlord. We started with that of the tenant. But then the way you actually spoke, you were able to marry the rights of both the landlord and that of the tenant. And that's a very good one. It's an education right here. It's an information right here. This is what we get on Global Morning. And of course, I don't know, there is supposed to be a smooth relationship between the landlord and, of course, the tenant. But in most cases, reverse is what we get. But as it is, I think